Well, now we'll talk about transfer pricing in the CEE. As some of you know me, I'm from Italy, although here is written that I'm from Austria, because I work and live in Austria for a while. My name is Rafaelle Petruzzi. I'm the managing director of the BU Transfer Pricing Center at the Institute for Austrian International Tax Law at Vienna University of Economics and Business. Almost said it in one shot without even briefing. And I'm also of counsel at LMP, Ludovici, Piccone and Partners, where I work with Giammarco and other colleagues in Milan, Rome, London, and Vienna. What we will discuss now is, as you know, it's transfer pricing. I have a great co-panelist here. I'm happy to introduce all of them. You already know Svetislav. I probably don't need to introduce him again. We have here Katalin Sikos Buzora. I hope I made everything wrong, but at least Katalin, I think I got it right.
Yes, exactly. That's what counts.
She's from the Hungarian Tax Administration. She's responsible for the APA and MAP team. She has basically a lot of years of experience in dealing with transfer pricing, coming from private practice, and so she's really well expert of the APA and MAP programs. We will see. She will give a presentation on that, and I think we can learn a lot from the Hungarian experience. Here on my right, I have Alexander. Alexander Stefanov from Deloitte, Bulgaria, is also practicing for a while in this area. Is senior manager at Deloitte, Bulgaria, and he has background in law and economics. Then we have Ioana. Some of you already know her, Ioana Koronkiewicz.
Almost.
Almost made it. I hope Giammarco gonna get it right. So she's senior manager at KPMG Poland. She has been practicing for many years as well, international tax and transfer pricing. She has a PhD in law and economics. She is the chair of YIN Poland, and expert in various forums in Poland. Last but not least, we have Giammarco Cottani. I think I got it right, at least your name. He's the head of the transfer pricing practice at LMP, Ludovici, Piccone and Partners in Milan, and he has a lot of experience coming from previous engagements at the OECD. He has been part of the UN subcommittee for many years as well. He has been in the Italian tax administration as well, dealing with these topics. He is the guy that is responsible, at least has been working intensively on the chapters on intangibles and business restructurings, probably the most challenging topics at the OECD in the OECD guidance. So, and he also has been training tax administration in the Balkan region in 2014 with the World Bank. So, excellent panel. I would say what we're gonna do. We will have a presentation of maximum 15 minutes, even less eventually, by each of the panelists. I will be really strict with timing, although even if I'm Italian, on this side I'm German, and that's probably why I live in Austria. I get a good mix of the two, and then we will go with some questions, some debate in the panel. But of course, I want to encourage a lot your questions. So before we go into our questions, I would really be happy to receive questions from you. So I'll ask Alexander to have his presentation now.
Alexander, use this microphone.
Okay, I would like to speak standing, so if possible to use that.
Is that a problem for the translators if he's standing?
Do you hear me from here? Hi everyone, I'm glad to be part of this panel. Thank you very much, Sveta, and the organizers for inviting me. I'm really proud to present our small, but as you see, an important country, which is Bulgaria. So what about us? We are interesting. Why? Because we look very much like a regional low tax jurisdiction. Our tax system is, I would say, pretty simple. We have flat rates both for corporate income tax and for personal income tax, which are 10%. So it's very easy to calculate. Yeah. Our withholding tax is also 10%, and our dividend tax is 5%. Do we have treaties? Oh yes, we have treaties. We have treaties with almost all the major economies in the world, like all the EU member states, the US, China, India, Russia. So yeah, our tax system is, I would say, well developed in this respect. Yeah, we are a member of the EU from 2007, so all other, as you can imagine, developments like directives, regulations, stuff like that, they are applicable in Bulgaria as well. We don't have holding legislation, I would say, yet, yeah, because of some political reasons. So this is the general framework, I would say. What about the TP? Our TP framework is also, as a basis, well developed. We do have Armstrong Principle as of 1993 in our legislation. We do have positive rules about the 5 OECD methods as of 1996. That's 1 year after 1995, when the first version of the OECD guidelines was issued. So we were pretty advanced. Well, on the practical side, I will talk about this further on. We don't have so experienced authorities, so we don't have so much practice on the application of these methods and so on. But the framework is there, yeah. So what are the specifics of our TP framework? Well, we still have hierarchy of the methods. So the traditional methods like CAP, TNMM, CAP, RSM, and Cost Plus should be tested first before going to our favorite TNMM. Of course, most of the benchmarking studies are done through TNMM, maybe 85 to 90% in my practice. And this hierarchy, as you can imagine, it requires some extra work when doing the economic analysis. Yeah, there are some suggestions that it should be aligned with the OECD guidelines, which don't have this for a lot of time. But it's still there. What else do we have? Well, our definition of related parties is quite broad. Important to note here is we have very, very low threshold for relatedness, which is 5%. It doesn't make much sense from a business perspective, but it's still there. Poland had the same, I think, Joanna, like 2 years ago, but you changed it to 25, right?
Yeah.
Yes, we had 5% for several years, and we only changed in 2017 to 25. And in practice, 5% affected benchmarking,
Exactly.
like a lot.
Exactly. Thank you for this note, because yeah, this from practical perspective, this makes benchmarking studies a little bit specific. It's difficult to localize centrally prepared benchmarks for this reason. In some cases, businesses do take the risk and they use centrally prepared benchmarks, but we always advise them to think about that. Yeah, normally the authorities don't challenge them, but now the authorities' practices are developing very fast, and we expect in the near future that this will be put on the table. So, what else do we have? We don't have mandatory documentation requirements. Yeah, the burden of proof is to the taxpayer. In case of tax audit, the taxpayers are obliged to prove the compliance with the Armstrong Principle. This is normally done with TP documentation. So we do have detailed TP guidelines, which are not part of the law, but they are published on the website of the tax authorities. And part of this TP guidelines, it is called actually transfer pricing manual in Bulgarian. We have documentation requirements which follow the code of conduct of the EU on the transfer pricing documentation, which is from 2006. I think if we switch off this, it will be better.
No, if you switch, they can't hear.
translations
No,
don't
they
hear.
can't hear. we need to keep it on.
So we do have some local guidelines on the documentation. We expect very soon, maybe in the coming month, that there will be a draft law that is based on the OECD guidelines 2017 and BEPS 13. We know that, and 2 days ago on another conference, which I'm coming from now, the tax authorities made a detailed presentation and they publicly announced that. So we will soon have a big change in our framework in this respect. Our legislation doesn't provide for APAs and binding rulings, unfortunately, I would say. This is sometimes a big question when we talk with clients and foreign investors. I personally am one of the biggest promoters of this to be implemented in our legislation because, of course, it will give more certainty and more basis for foreign investments, make us more attractive. The 10% rate, I would say, is not enough. We need certainty and rule of law. So this is where we are. Yeah, I'll talk a little bit later where we want to be and what to expect in the near future. So the CBC reporting, we did implement the European directive with one very important specific, which very clearly shows that the tax authorities are very interested in the multinational groups. You know that the threshold, both under BEPS 13 and the directive, is 750 million euro. Below that threshold, the multinational group is not obliged to file a country-by-country report. Well, in Bulgaria, that threshold was dramatically reduced for the local groups. Maybe you understand why, because there's no Bulgarian domiciled group with consolidated revenue above this threshold. Yeah, so it's a lot of money for our reality. Yeah. But what about going below? Because you know the directives normally put a minimum standard and the countries may decide to go further and be either more stricter or more liberal. In our case, what's being decided, and I think we are unique here within the EU, that the threshold for domestic CBC reports is 15 times lower. It's 50 million euro, 100 million level. Within this threshold, the administration said that we have 26 Bulgarian groups, so they are interested in the big, according to our local standards, groups. And the interesting point here is that these reports, be careful now, these reports will not be automatically exchanged with the other member states. So, our administration took the chance to implement something that serves its own purposes. And it clearly shows that they're interested in the big groups. Our fines are really severe, I would say, for not complying with the CBC reporting rules. Businesses are really concerned in certain aspects because the rules are not very easy to apply. We still don't have a bilateral agreement for exchange of information with the US, which will be very soon a problem with all US subsidiaries in Bulgaria because according to the letter of the law, they'll be obliged to file a CBC report in Bulgaria, the so-called secondary filing. And unless the US group decides to appoint a surrogate parent entity elsewhere in Europe, I don't think this will happen. So our administration will be facing the question, are we fining, are we imposing fines, or we wait until the treaty is concluded? This is what I expect. Because I heard that it will be delayed. The process on the US side is very long and they are doing a kind of peer review. Due diligence of the country. Can we share information with the country before signing the treaty? I don't know, do you have in Italy such treaty?
With the US, we are currently negotiating it. But
you're still negotiating it, so imagine when this will happen for Bulgaria, when Italy is not there yet. Okay, so what about our local practices? TP is one of the hot topics in the tax area in Bulgaria in the last 2 years. Authorities, I think this is a global, at least European trend, shifted their interest from the indirect taxes area, like VAT was their favorite in the last, I would say, 20 years. But the EU Court of Justice and the directives developed so much, they answered so many questions, so maybe they are not so much of priority already. Yeah, if in the past maybe above 50% of the audits, at least in Bulgaria, were about VAT, now we see increase in the interest of audits in direct tax area, and of course TP pops up. The tax authorities made a gap analysis, so they tried to reach out to a conclusion what is the expected revenue versus the real revenue of the state. They noticed that the gap is approximately 130 million euro per year due to transfer pricing, and they developed a strategy how to handle this, because this is a lot of money for a small country like Bulgaria. So what they started to do is they build a plan to check all the multinationals, starting from those which are most likely to have TP issues, like the loss makers and those who pay a lot to the group outside. So those who are who incur a lot of expenses towards the group. So we see that for 2 years, and it's increasing. And it was publicly recognized by the tax authorities many times. So they are doing this in an organized manner. The large taxpayers directorate is now trying to form a specialized unit dealing with TP. I heard about Hungary that they do have already such team, so you're a good example. I talked with the director of the large taxpayers 2 days ago, and she said that they are trying to increase this and have more people in the team, so that they are more efficient. So this is really a priority for them. Many Bulgarian cases, generally, when there is a tax assessment, well, our I would say culture is choosing the court appealing rather than going to MAP. This is the reality. So in many cases, the TP adjustments go to court. And our court has a lot of experience with dealing with tax disputes, including transfer pricing disputes. Yeah, we don't have a specialized tax court, so the tax cases are reviewed by the administrative courts. The Supreme Court reviews tax cases in 2 of its divisions, I think 1st and 8th division. There are a lot of cases, and I would say there is established practice on few interesting areas from a practical perspective. I try to summarize a few of them here on 4 bullets. For example, our court says you cannot use statistical information on the interest that is extended by banks to non-financial businesses. Why? Because the statistic doesn't provide sufficient information to make a comparability analysis. Yeah, I know in other countries it's not like that. In Bulgaria, the court says you cannot use the public statistics. What can we use then? And there are a lot of talks about introducing a safe harbor interest rate, like I know you have such in Serbia, right, for 2 years. So we still don't have it. But I believe this will change soon, because the business is really concerned about the situation. What else?
Alexander, 1 minute.
Sure. We do have practice which says that you cannot use offers, and you should use only information on actual transactions in benchmarking. That's also very important from practical perspective. About downstream mergers, this is some bad news for the M&A guys. The court says you cannot deduct interest at the receiving entity in case of downstream mergers, because this is deemed tax avoidance. And this is, I think, very, very important. When you have a tax audit that is accomplished for the one side of the transaction, and there's no TP adjustment, this can be used as an argument not to have a TP adjustment on the other side, because you would have a double taxation. I would say this is a universal principle that can apply elsewhere. So if someone is interested in this practice of our court, I will be glad to share it. What can we expect in the future? Well, as I said, more activities from the authorities, new legislation on the documentation. Now the authorities are in the process of obtaining license to TP Catalyst, the Bureau van Dijk Amadeus professional version. And we do expect that they will have specialized TP teams, and we will have specialized TP audits in the very near future. maybe it's time also to think about introducing APAs in our legislation, because when introducing this, I would say, compliance cost to the business, you should give also the business the opportunity to ask for more certainty, which the APA gives. So to summarize, we are quickly progressing towards implementing all the current, I would say, features of the TP framework globally, and we want to become like an OECD member state in this aspect, although we are still not. This is also part of the plans of the Bulgarian government. In 2 years, they want to become an OECD member state. So we are quickly progressing in this respect. So TP is and will be one of the priorities of our administration, and on the focus also for the business in the coming years. Thank you very much.
Thank you very much. And we move to Joanna.
Right. If So if Bulgaria is running towards a new TP environment, Poland is speeding. For Poland, I would like to briefly introduce the TP profile as it is in 2018. Then I would like to share with you some statistics I received from the Ministry of Finance when I inquired for access to the public information. I believe that these statistical data are very useful and tell us a lot about the Polish tax administration perspective. And then it is worthwhile to understand peculiarities of the general corporate income tax system in Poland, and finally 2019 TP reform. So, yeah, this is the slide. No, the previous one. Thanks. We do have the arm's length principle for many years in Poland, both for cross-border and local transactions between related parties, including between headquarters and its PE. Threshold for being related, as already said, has been increased to 25% from very low 5% only in 2017. The OECD guidelines are not formally part of the Polish legislation system. We don't have it translated officially into Polish language. And in practice they are used quite inconsistently by both taxpayers and tax administration, depending on what suits the case. So this play goes on both sides. The courts tend to treat OECD guidelines as important source of methodology, arguments, and common sense, but I cannot say that the court has a lot of experience with TP cases in Poland, because taxpayers tend to find alternative solutions or dispute resolutions mechanism rather than going to court. The courts are seen as inexperienced with business understanding, and that's a great threat in terms of TP disputes. 5 TP methods are listed in the legislation in the context that the tax authorities must use the most appropriate out of these, and no other method could be applied. On the other hand, a taxpayer is free to use any method, but in practice they try to use one of those listed in the regulations. For 2018, we don't have any specific regulations on intangible, especially hard to value intangibles, or no safe harbors are available. Finally, advanced pricing agreements are available in Poland for years. Transfer pricing documentation in forms recommended by OECD is required by law in Poland, unless taxpayer holds APA, advanced pricing agreement. What is characteristic for Poland is that a taxpayer not holding or not having a TP documentation and against whom there would be a TP adjustment would be liable to a penalty tax rate of 50%, 50, instead of a regular tax rate of 19%. The penalty rate would apply to the adjusted part. Now to the statistics. The number of TP audits decreases in recent years, as you can see, but the overall TP adjustment value increases, and that's the goal of the ministry, targeting TP riskier taxpayers and focusing on them. But what are the mechanics of identifying riskier taxpayers is not publicly available. One of the factors that we see in practice is definitely being on a tax loss position, already mentioned also for Bulgaria. So repeated tax loss reported by a taxpayer might cause audit. In terms of APAs, I wouldn't say that the overall number is particularly impressive. One of the reasons is mistrust between taxpayers and tax administration. For APA procedure, you must understand that the taxpayer must be transparent to get this tax certainty that Kathleen was mentioning for Hungary. Also, the cost of obtaining the APA might be even more than 50,000 euro for a bilateral or multilateral agreement, and to that you must add cost of being in the lengthy and burdensome procedure from the perspective of a taxpayer, and also you need to add cost of a tax advisor on top of that. The Ministry of Finance is familiar with the mutual agreement procedures, mainly based on the EU Convention or double tax treaties. Out of 75 motions for the last decade, only 12 were completed with consent between the administration, and that resulted in 40% reduction of TP adjustment from the perspective of Poland. To me, this percentage is shockingly high. 40% of TP adjustment suggested by Poland was denied. Then also worth mentioning that Germany is our most common negotiating partner. No country from the CE region I spotted in the statistics as a significant adversary, but it's all logical. Germany is also our main trade partner. Finally, the tax administration is subject to major changes in Poland. There is impressively increasing use of technologies by the tax administration, starting with the statutory audit file reported electronically by all business taxpayers, even the smallest ones. One of the changes is also specialization, supported with training and tailor-made postgraduate TP studies for tax officers. There are teams of tax officers being created specializing in transfer pricing all over Poland, I mean in regional tax offices. Also post-Big Four experts are being regularly recruited by the Ministry of Finance for the last 2 years, which wasn't the case before. As a result, a center of competence has been created centrally in the Ministry of Finance to fight abusive tax optimization, including the one basing on transfer prices. Each tax auditor during tax audit can request a brainstorming session with that competence center, so with this central team, on a specific case and learn the options to move forward. Nothing officially, but some help, instructions, support can be centrally delivered this way. It's not transparent, so we don't know how it works. I mean, we as tax advisors. And another slide. So before I jump to the hottest TP reform in Poland, I would like to take a few minutes of your time to explain the challenges Polish taxpayers are facing in the context of TP. Here's a pyramid illustrating the reduction of tax deductible costs allowed for a taxpayer. Shortly, at the bottom, you see a business model with operating costs and revenues. Then, firstly, a taxpayer must exclude all costs listed among over 60 statutory non-tax deductible costs defined in the Polish CIT law. So, having some business model, firstly, you exclude a great bunch of costs. Even though only up to 20% of those non-tax deductible costs are permanently non-deductible, the effort of identifying permanent and temporary non-tax deductible costs, or those adjustments, takes a lot of time and results in a sort of tax-adjusted business model, right? So this is the first step. We're not discussing for CIT purposes or on your business model. We're starting to discuss on a tax-adjusted business model. Then, at the next level, as of 2018, a taxpayer is asked to exclude costs of immaterial services, like marketing costs, like legal costs, like accounting support costs, reporting costs, purchased from related parties in the amount above 750,000 euro plus 5% EBITDA, regardless of the fact if those costs meet arm's length principle or not. So, you already excluded a bunch of costs, and now you're excluding cost of services purchased from related parties. And more interestingly, if you bought the services from unrelated parties, those costs would stay in the tax result. So to me, it's a bit discriminatory. But if you ask the ministry, they claim that it's a specific anti-abuse clause against taxpayers transferring too much of their profits abroad. But too much is already addressed by TP regulations. If you claim it's too much, then find an arm's length transfer, considering functions, risks, and assets. So I cannot reconcile these two principles: arm's length principle and this, by definition, non-tax deductible costs of services, immaterial services purchased from related parties. This pyramid is just to show you that theoretically we might be discussing about OECD guidelines and about arm's length principle, but if you need to make those first steps, excluding significant part of costs, the question is, what are you referring to when you discuss arm's length? Can I switch to another? And finally, the published draft of TP reform proposes changes to reduce the administrative burden imposed on taxpayers by increasing the documentation threshold and introducing safe harbors. Also, a master file in English will become acceptable, whilst the reporting deadline will be extended from 3 to 9 months after the end of a tax year. However, at the same time, the draft law grants broader powers to the tax authorities in the area of assessing the merits of transactions between related parties. So in terms of margin rates for low value added services, the level is set at the minimum of 5% for the provision of services and a maximum of 5% for the purchase of services. So in short, 5% is a safe margin for low value added services. A similar solution is proposed for loans. If the interest rate on the loan is determined on the basis of the base interest rate plus margin as published by the ministry in a decree, a taxpayer would benefit from the safe harbor. So there would be a predefined level of interest, and if you are in the limit, then you're safe. There are some conditions to the loans which are covered. For example, they cannot be granted for more than 5 years.
1 minute.
Yeah. Sorry.
1 minute.
Right. The catalog of TP methods would be extended in a way that there still would be 5 methods listed, but there would be an open clause. If application of those is impossible, the tax authorities would be granted the right to use any method that would lead to the arm's length. But on the other hand, the proposal would give tax authorities the right to recharacterize the transaction or even to disregard the transaction if the tax authorities conclude that unrelated parties wouldn't enter into such a transaction or would enter into a different one. And there are no, at this point, no instructions how to apply this clause, and to me it's a very broad one. So summarizing, as of 2019, we might end up with lower TP compliance costs, but with higher level of uncertainty and being uncertain about the merits. Also, exit tax would be introduced. We are talking about cooperative compliance in Poland. Intangible services will remain undeductible, so there's quite a lot of part of tax environment in Poland that impacts the discussion on arm's length. And I would leave it open to discussion for the days.
Thank you very much. So you're next?
I'm next. Can I have the microphone, please? Just a little bit. So, thank you.
5 minutes for you, since you have really been talking a lot in this conference.
I agree with you. And what my presentation, I'm not going to present too much of the Serbian specifics. I want to show in my presentation 2 things. One is... Sure. Actually, so I'll have 3 basic points. One is to illustrate the relevance of exchange of ideas in this region, because I will try to show how we relied on the experiences of other countries, predominantly Hungary, when we drafted certain Serbian tax rules. Certain things that we just heard that our colleagues in other jurisdictions are doing that we are not doing, and some ideas how we can use some of the mistakes that we've done in the past. So the Serbian transfer pricing story, this is a broad outline. It started in 1991 when we introduced our transfer pricing legislation, the arm's length standard. At the time, 2 methods. And then we forgot about these rules. Basically, we introduced them, we didn't really understand what they were for, and also the cheerful 90s began, which meant that no international transactions were actually taking place, so we didn't really care about this. In 2001, we introduced the 3rd method, the resale minus method, And then we again forgot about these rules because we were busy with other things, which was understandable. Until 2008, 2009, when one particular tax audit, and I think most of the Serbian tax community knows the company that was involved, but I will not mention them. See, people are laughing, then they know raised panic in the Serbian tax community because the results of that tax audit were so different to anything which you would have expected under the arm's length standard that in 2012, the working group of the Ministry of Finance was issued with an order by the minister, fix transfer pricing. I was a part of that working group and I've heard this order live. So because the businesses and the investor community were saying we will leave the country because you are so completely out of your minds and doing things completely differently than everybody else that this needs to be fixed. In the meantime, this association, the Serbian Fiscal Society, managed to translate the 2010 OECD transfer pricing guidelines into Serbian and actually distribute this translation to most government authorities, courts, as a gift. And then we tried to do something in 2012. Were very, I think, modern for the time. In 2012, we already introduced the sixth method, imaginative, if you imagine anything that's under and that will fall under the arm's length standard, that's okay under our rules. But again, I think that once we did the job in 2012, we again forgot about transfer pricing. Now, because there's a documentation requirement, still we see no developments, and what I think is very important is what our colleagues from Hungary and Poland are saying, is that we should not be wasteful, and I think there's a tendency to be very wasteful, and we should not spend huge amounts of money on training the entire tax administration. Small and effective teams are quite sufficient, and everybody who does transfer pricing knows that this is definitely the way to go. You have 230 inspectors in Poland. Now Poland has 40 million, we are 7 million, so divided by 6 and you come to a number. If size comparison, it's under 40 inspectors for a country like Serbia. Hungary is 20 if you combine them all. So you're 10 million, we're 7 million, you get to a number of under 20. And plus their GDPs are roughly around twice our size, so we can do with a few less. But specialization is, I think, the way to go, and it's the only thing that will bring any success in this endeavor. Now, one thing that we've done, and actually we copied Hungary, we follow the Hungarian example. We introduced exceptionally strict documentation requirements in 2012. Serbia is the leader in strictness. We demand TP documentation to be submitted on an annual basis together with the tax balance sheet, and pretty much nobody else does this. Now, why did we do this? Well, we looked at Hungary, and we learned that in Hungary, the obligation is to submit documentation immediately upon request, so at the time, and we learned that the Hungarian penalty was 7,000 euros approximately at those exchange rates per contract. That was not substantiated by documentation, and we said, well, essentially that's the same thing. If you don't have it ready and you have to present it immediately and you're penalized in such a harsh way, well, effectively that means that everybody should have something ready at a moment's notice. And then we said, well, this is one thing. The other thing is, how do we educate our tax administration? How do we provide them with the capability to build up their own standard? And because mostly practitioners wrote these rules, we were of the opinion, we thought, how did we learn transfer pricing? And they're tax practitioners on the panel, so they'll say if we were right or we were wrong. We thought, well, we learned it by reading transfer pricing documentation prepared by those of our colleagues who were more advanced than us. And it's not, you read the OECD transfer pricing guidelines, that's fine, but actually it's from the very work that you look at, you see that you can build up your own style, your own approach, your own view. So what we wanted to do, we wanted to provide the Serbian tax administration at the time with the best transfer pricing library in the country. So everybody would submit, they could select, and they could make approaches based on the types of transactions, type of businesses, really have a very, very detailed file. And once in 2, 3, 5 years, when this is all selected and the databases are built up, and then we can be more lenient. The problem is that this opportunity, in my opinion, and I have no reason to believe otherwise, has been completely missed. It's not been used at all. And this is why it was put into law. So, judicial capacity in Serbia in the area of transfer pricing is non-existent. There is one case, and that one case shows at what level we are. In the case, which is roughly the value of the case is 1 million euros, transfer pricing value. Not transfer pricing, sorry, tax value. The adjustment is at those rates 10 million. There's one sentence, and this sentence says the following: we have looked at the details of the case and found that there is no reason to judge otherwise. So, and this is now, mostly these cases are dealt by the Constitutional Court, who thinks that this is lack of argumentation, that this is not a ruling which meets constitutional standards for a judgment. Yes, basically, rule for a fair trial, you need to argue your decision, and this one sentence, that's not an argument. So, we can't rely on the judiciary. So what do? We have an incredible amount of paperwork submitted, which is on file in the Serbian tax administration, which allows us, until we build up the sufficient capacity, to actually look for, I think, something which is the Brazilian method. And that is to introduce a number of safe harbors. Now, what does that mean? Well, that means the same thing we done for interest. We provide a rule which essentially says if you're within this range, and we provide you with a formula how to get to the basis under which the range is measured, you're fine. You don't have to do any documentation, no benchmarking, nothing. Calculate this, and if it's in the range, you're good. Now, unlike the Brazilians, who had to pay many consultants huge amounts of money to bring these safe harbors, we already have the data. We have 5 years of all TP documentation in Serbia, in the Serbian tax administration, so we just need to select. We can't do all transactions, but we can do some. This will, I think, greatly increase the level of legal certainty. It will allow the tax administration to focus on those transactions where there's really abusive potential and not be lost in the myriad of transactions which take place. And plus, it will give us time to, I'm not very religious, but this is a time for, atonement. So the taxpayers have been paying for 5 years our desire to build up capacity. We have failed to use the opportunity. Thus, let us pay them back with more legal certainty and safe harbors, which I think businesses love, because it makes them feel good. Plus, tax consultants will not lose the work, because tax consultants are well represented in the room, and they know how prices fell with respect to regular transactions which are no longer feasible to be done under any hourly rates. So you'd be able to concentrate on the fee-making aspects of transfer pricing, and not on the useless compliance work, which we're now dealing too much with. So those are my 5 cents, and I try to be provocative, at least to a little extent. Thank you.
Thank you very much. We now move to Giammarco, and maybe you can also introduce us to the work that you do in Ludovici, Piccone and Partners before
yes,
you
briefly.
speak.
First of all, dobar dan, and I would like to say, first of all, hvala to Svetislav and Serbian Fiscal Society for inviting us. I mean, I had a feeling that this was a special event. I realized that when I arrived late Wednesday night in Belgrade airport, because I was walking, was around midnight towards the exit, and all of a sudden a customs guy appeared in front of me and said, "What do you have? Staj ovo, brate." It was like, I had basically this bag where I was folding the banner, so I had to unfold my banner and say, yeah, there is a big tax conference here. And so you're known also now to the custom agency in Belgrade airport. Well, we're very happy to sponsor this event, also because we see that, at least in our practice, the interest of Italian multinationals towards Central Eastern Europe has always been there, but now is increasing. Italy's second trading partner of Serbia after Germany, and therefore there is a strong attention into that. In 15 minutes, I promise I will try to give you, I've been asked to show you the major update that I worked on the transfer pricing manual, on the United Nations transfer pricing manual that was published in April 2017. I'll try to give you a little bit of an highlight and compare it with the OECD transfer pricing guidelines that were published in 2017. And I'll try to give you with a practical example how this would fit into the reality of Serbia and other, of course, Central Eastern European region like Hungary and Poland and Bulgaria that can be affected by it. So, first of all, the United Transfer Pricing Manual is the outcome of the work of a subcommittee on tax matters composed by both representatives of tax administration and private sector. At that time, when I was part of this subcommittee, I was still with the Italian Revenue Agency, and it was a 4 years work. So a first edition was published in 2013, and then there was an update request by developing and emerging tax administration on areas where they see most problems. First of all, what is the legal value of this manual? I think that as well as the OECD transfer pricing guidelines, the value of this, I would say, not even secondary law, it's a soft law, so that these are recommendations that you may want to look at when you are applying a tax treaty. So if I take the example of my country, Italy, that we have a little bit outdated network of tax treaties, we negotiated most of them not on the OECD model, but on the UN model. So this means that, for example, it was my experience that when I had to deal with a bilateral APA arrangement with China, China has been one of the tax administration that was very vocal in supporting this work. They asked to use as an interpretation tool for Article 9, not the OECD transfer pricing guidelines, but this manual. The reason being the fact that you have a number of chapters in this section D. One of them is China, where each tax administration can reflect their own views. Now, is this document different from the OECD transfer pricing guidelines? The answer is no. The answer is, can you go back one slide? Thank you. The answer is no, because both of them are founded on the Armstrong Principle. The main difference being that you have way more practical examples than, let's say, the policy advice that you have in the transfer pricing guidelines. For example, looking at the new chapter, B5, transfer pricing consideration on intangible property, the principles are, I would say, somewhat identical to the one that you would find in the new chapter 6 of the guidelines, but there are some differences. You would see, for example, that there is a different definition of the so-called DEMPI functions, because I know that both OECD and UN likes acronyms. So in this OECD acronym on chapter 6, DEMPI function refer to all these functions that would add the remuneration that you're going to attribute to the entity that supports the development, enhancement, protection, or overall, exploitation of intangible property. Here, in this chapter, you have an additional letter that is an A, so you don't have to spell it DEMPI, but DAEMPI. And the A stands for acquisition. Why? What does it mean, acquisition? There was the US delegate, the United States in the OECD were very vocal in acknowledging the role of funding activities to develop or acquire IP. So the US took the chance of having this more, I would say, freedom in presenting their views, so they added a letter A, meaning that if you have an entity that within a group not only performs, let's say, important marketing functions, but as well fund the activities that are instrumental to such a development or an acquisition of the IP, those will have to be remunerated accordingly. I think another major point is that IP, or intellectual property, in the UN manual has a slightly different meaning in the OECD guidelines. The reason being that in this UN manual, IP refers to all the assets that warrant a remuneration above a routine return. So rather than focusing on a significant legal definition, you will have more, I would say, attention towards the economic analysis of it. Another interesting area is the chapter on business restructurings, because In business restructuring, there are, I would say, unlike the new Chapter 9 that was introduced in 2010 by the OECD and then revised, there is a slightly wider definition because, for example, M&A transactions that normally are, I would say, instrumental to lead to business restructuring, here are part of the definition. And more importantly, in this chapter, you will have an expanded definition of the role of goodwill as a kind of accounting element that you will have to factor in the association that you're going to perform when, for example, you need to establish what is the profit potential that is connected with the transfer of a bundle of assets. Interesting, what is the role of the country chapters? There is a big foreword before this section D that report the chapters of Brazil, how Brazil, China, India, Mexico, and South Africa deal with transfer pricing. Again, also here, I would say the developed tax administration wanted to put a big forward in saying, look, these are just a mere description of administrative procedure in a single country. This does not mean that this country should not respect what then is agreed at the international level. As you can easily imagine, the answer is no, because when you're going to deal, as Svetislav referred, with Brazil, Brazil is going to talk to you about transfer pricing without respecting the Armstrong Principle, but trying to apply their own domestic rules as much as possible. China and India will be very vocal in acknowledging the role of markets as the so-called location-specific advantages that would justify a greater remuneration for otherwise a low-risk distributor, whereas Mexico and South Africa presented their own views on a comparability analysis. Now, a big point, thank you, is the distinction developing versus emerging. I remember when we did a program with the World Bank in 2014 in Bosnia, and frequently I remember that representatives of Federation as well as Republika Srpska were saying, look, Giammarco, we are a developing tax administration. How can we apply rules in the same way that the US, the Netherlands are applying in transfer pricing? And in my opinion, this distinction, developed versus emerging or developing versus emerging, has absolutely no sense in a tax standpoint. Why am I saying that? Because in transfer pricing you have one basic, relatively simple economic concept that is the one of the Armstrong Principle. Where you have the problems and where you have the differences is the fact on how you implement these rules, and I think it was the point that Joanna, Kati, Svetislav, Alexander pointed out in what they're experiencing in their countries. The problem is not the lack of a legal framework. You can agree or disagree, particularly I think it's very interesting what you said about Poland, but the problem is that you need to have the people and you need to have the instruments, for example, databases that are very expensive to get access to this information. But maybe we can touch upon later on. So in my opinion, what is really significant for Central Eastern Europe is what is the level of administrative resources that you want to invest long-term in guaranteeing proper enforcement of any legislation. I can tell you that in Italy, we are not sitting on cash of surplus. I think we are the second largest indebted country in the world. After the new government, we will be even more indebted. But that's another story.
We can become first.
Yes, exactly. So, but when we started transfer pricing implementation in Italian Revenue Agency, the starting point was 7 people. 3 economists, 2 lawyers, 2 chartered accountants. And to grow the knowledge, what we did, we introduced an APA system because that was the way to learn from the private sector. Last slide. If I compare now the OECD and the UN approach, and imagine that in this structure, that is a common structure the multinational group adopt, Serbia can be, or any other country that is represented here from Central Eastern Europe is involved. Maybe if I follow the OECD and the UN approach, I can get possibly different results. So if you allow me 2 minutes, I will show you what this structure is all about. Imagine that if you can see on top you have the parent company, the headquarters, charging management fees to an R&D center. Okay? Imagine that this R&D center is located here in Serbia. You have an R&D director, scientists, engineers, and application specialists that perform R&D activities. and they will be remunerated for this contract R&D services that they will render to an IP owner that is normally located in a low tax jurisdiction. So without making names, imagine that the IP owner is in Luxembourg or in Ireland, you have that quarter in the US, you have an R&D center in Serbia, and then you have a distributing operating entity, group operating company at the bottom end of the slide in Bulgaria. In Bulgaria you will have a production plant, sales force, sales director, and they will ultimately sell and retail the product to the market. The issue is, how am I going to look from a tax administration and a taxpayer standpoint to this transaction? In my experience, in Central Eastern Europe, one of the biggest problems that you have is how do I get the management service fees accordingly? And I think, Joanna, you mentioned rightly that often, at least in the experience that we see in our day-to-day practice, a big point of discussion is assuming that the headquarters is the Italian banking group with let's say, our R&D center, or let's say a retail group in Italy with an R&D center in Serbia. I charge management fees for supposed marketing support activities in Serbia, and I decide to remunerate these services with a cost plus 5%. The approach by the local tax administration is, I'm not sure that your cost base is correct, because staff in Italy cost is way more expensive than staff in Serbia. So I want to go for a different methodology. What shall I do? If I follow an OECD approach, I'm going to obviously look at the fact that what a third party, if I want to apply, let's say, the CAP method and all the 5 comparability factors are respected, whether this can be a comparability factor and whether or not I can adjust. If I follow instead the UN approach, the UN will be always more, I would say, careful in protecting the interest or the activities where, let's say, sources of value is generated. And you can see that this can also be applied, particularly if I look at the fact that the group operating company, that in my example here is in Bulgaria, selling product, having a sales director and sales force in Bulgaria, is paying royalties to the IP owner in Ireland against the licensing arrangement. Now, countries that have been very vocal in the UN would try to say, look, the key risk with respect to the distribution activity cannot be entirely centralized at the level of the IP owner. And therefore, you cannot remunerate with just a little routine remuneration the group operating company. But the OECD approach, as you will find in Chapter 6, would be who is controlling the risk in terms of who is managing and taking the key decision with developing the intellectual property. In this case, it would be a trademark that I would exploit to sell the product. So I'm trying to summarize what could be discussed for hours, but keep in mind that now if I try to summarize how different responses can be, possibly the different response lie in the way tax administration will look at risk. Can risk be centralized in an entity? According to the OECD wording, possibly yes. According to the UN manual, I can discuss and debate that risk can be economically shared. This is what I wanted to mention in 15 minutes. Thank you so much, and I hope that we will have discussions.
Thank you very much, Giammarco, and thanks again, everyone, for your great presentations and for keeping the time also, so that now we have a couple of hours to discuss about these topics. There's still someone alive. All right, so we can start with the questions, but what I wanted to point out here is that I think in general it seems that there is a lack of investments into this topic. Both the tax administration, probably the taxpayers and the advisors are investing more on this topic. Tax administration seems to invest less. The main issue and the main point that I want to make here is that in here is where in corporate income taxes you make money. So if you don't invest in here, I think you are investing in the wrong place. So train your tax administrations. We have excellent courses in Vienna. They are fairly priced, and they are absolutely really practical. We have a lot of main experts in the field in here, so feel free to come. We'll give you a lot of excuses to come to Vienna. It's a beautiful city, apart from the courses. So, invest resources in here, first of all. Second, I have a lot of points that I've written in here, but I would like to have more discussion within the panel and with you on these topics. But probably the first issue that I wanted to address is whether you know what happened on 23rd of May 2016. Two major events in that day in the history of the world. One, probably something that women might know. 23rd of May 2016. What happened?
You got the Austrian passport.
Google it.
So, Johnny Depp filed for divorce. This is something that everybody, at least the women, should know. The second, and probably this is more for the transfer pricing experts in the room. What happened on 23rd of May 2016?
Commission? State aid?
No. The OECD Council approved the amendments to the transfer pricing guidelines. So all the BEPS amendments, like hundreds of pages of work done by the OECD in BEPS actions 8 to 10 and 13 that were issued in a report in October 15 were approved in May 2016. Why is that an important date? Because now we are puzzling everyone, tax administration and taxpayers, with what is the nature of those amendments. As Giammarco has pointed out, those amendments are not changing the legislation, so basically you don't need to change your legislation in order to embed those amendments, and probably the transfer pricing actions in BEPS are probably the most direct actions that have been implemented by everyone at the same time on May 16, because all the other actions need enforcement into the national law. And so the question is, what do you do now with these amendments? On one side, the countries that think that those amendments are simply clarifications of what we already knew. So we can, in theory, apply those concepts developed in BEPS to transactions that also were in place before May 16. And on the other side, countries and in general opinions that think that those amendments have radically changed the world of transfer pricing, the OECD guidance, and therefore you can apply those amendments only starting from May 2016. So, how many of you think that those were just clarifications? Maybe you can raise your hands.
Some of it was.
So no one thinks that those. And how many of you then think that those were radically changing the OECD guidelines? All right, we have 2 hands for the second and 0 for the first one.
I'll raise my hand for the approach that you go for the substance and not for the contract. That's just a clarification.
So we have 2 against 1. I think the answer, as all the time in transfer pricing, is it depends. So, well, maybe we can start from the panel to let us know what they think. Alexander, you want to start on this point?
That's a fundamental question, I would say. Thanks for bringing in. We are so much in the details sometimes, in the technicalities, and we forget the big picture. And after the date of the divorce of Johnny Depp, we have to think differently, probably, as you noted. Yeah, I remember before that the transfer pricing guidelines were that thing. and now they look really differently. You remember that the pocket guide of the IBFD now is not pocket size anymore. It's a big book. Have you seen it? Yeah, it's a big change in the transfer pricing framework. So I think it's an important question, mostly for the countries where there's a direct reference to the OECD guidelines, like it's not elsewhere in Central and Eastern Europe. I know, for example, that in Romania, there are people from Romania, you have a direct reference in your legislation to the OECD developments, right? Well, we don't have. So I think the answer will be really different in the different countries. That's my point. So
what are you doing in your country?
We are not thinking about it yet. Yeah, we are so focused on the technicalities and we forget the big picture. That's the reality. I think the remark that you made is very important, and we can make a parallel, for example, with the OECD commentary on the Model Tax Convention, which clearly says in Chapter 1, or I think in the preamble, what is the relevance of the updates of the commentary? So, because more or less the OECD guidelines, there are a big explanation what the arm's length principle is. So it's very easy to say they should have retroactive effect because the arm's length principle was always there. So what do we change? We just give additional clarification how this should have been applied in the past. But if we look, and this should be, I think, the standpoint of the tax authorities. It's so easy because it gives them so many instruments to challenge and to require more, to apply substance over form, all these beautiful concepts. But if you look at the perspective of the taxpayer, what is the problem? The problem is that if I knew about this, I'm sorry about the word, about this DEMPI, would I act differently in the past? So the concept of legal certainty, I think, is the main problem here. Yeah, we talked about BEPS for such a long time. It started in 2013, but still there were so many changes in the process. So could we really blame the business that they don't think on such a high level like a TP experts and haven't considered this in the past when applying the arm's length principle? So the answer should be somewhere in the middle, I think. So for some really radical changes like the analysis of intangibles, I would say it's not fair to apply them retrospectively. There's too much money at stake, and I think there'll be a pushback from the business a lot. Yeah.
Thank you very much. And I mean, if you read the decision of the Commission on Amazon case, you read that the Commission has applied DEMPI analysis to a case that was dated 2006.
I'm not surprised.
You already start seeing that this will come also into discussions into your countries. I think we have a question from the audience first. Sorry, Dana.
Yeah, thank you. I will just continue because I think that now that we have a lot of small and medium-sized enterprises facing that problem, not having enough financial and intellectual sources in the companies. And don't forget that there are a number of countries having no exemption for CMEs. And I think that's the way. I think we should have some exemptions for CMEs in that case.
Wait a second, I have here Sveta first, and Giammarco second, and then who else?
Well, I have one comment, and then I will abuse the panel, but I can't because I'm the organizer.
And I want to be invited next year as well, so I will let you.
And this is precisely it. So that will be the point. I just want to show you one line of reasoning with respect to whether or not the OECD guidelines 2017, whether they're introducing something new or is it not something new. Well, the approach that is based in substance, and this is where I'm going to bring a parallel. In 1991, in Serbian legislation, this is where we found the argumentation for imposing harsh compliance regulations. In 1991, the law stated the following: the taxpayer shall, in the tax balance sheet, state the amount of income or expenses with related parties at transfer prices, and then in the line below, the same amount but calculated under at arm's length prices. Now, when we were justifying harsh implementation requirements, we said, well, when I was in elementary school, I hated mathematics. That's why I went into law. So I would try and sit near a very good student, and I would copy the result when we had the test, and I would still get an F. Why? Because my teacher wanted to see the procedure, how I got to the result, because he knew I copied it. So we thought, well, if you're demanding from the taxpayers to enter this number at arm's length, well, demanding documentation is basically, let me see how you got to this number. What I'm just doing right now, I'm formalizing how it looks. But from a logical perspective,
Yes.
it makes sense. You should have done this since forever.
Yes.
While everybody, and if the Serbian crowd knows this, in 2012 everybody was saying you have introduced documentation requirements. I didn't want to be spoil the party, but my personal opinion was it was always there. It was just not, there was not just a formal requirement, but the tax administration could have asked since forever for some show how it got there. So I'm not sure whether we are actually, I think what the Commission is doing with state aid cases and implying that the Article 107 of the Treaty of Lisbon has had a transfer pricing component since 1957. I don't think that's normal because nobody got it for 60 years. But, and it's very difficult to get to that result. But otherwise, yeah, the substance approach is something which I found logical. Now, the abuse part. What
I thought this was the abuse part.
No. This is where I start abusing my position. I would like to show, especially to often in Central and Eastern Europe, as Giammarco pointed out, we complain too much, and I think we're very spoiled. And
I didn't
so
say that,
well, I will because I'm local. I'm a native. So there are three persons in the room that I want them to stand up: Šimić, Katarina, and Vuk Gerić. Okay? Now, these three people that...
Whatever they did.
And this is what I'll show you. They've taken upon themselves, together with small help from me, to translate the 2007 OECD guidelines for free, and it will be published next year by the Serbian Fiscal Society. So, and I would... They don't speak Hungarian, but we'll learn them. So thank you very much. And we fail... I'm sorry for abusing you can say it. We fail to see how much potential and enthusiasm can be used, that you don't need funding. We'll do this for nothing. We can develop this practice provided we are not wasteful and that we rely on each other and talk to each other. So these three kids, all from Deloitte marketing, will do this, but it will be our association that will translate it. And when we do, you're all invited for the promotion of the book.
Thank you very much, and I'll get that as an official invitation, so I'll start booking my trip. I hope your math teacher is not listening the YouTube registration. Giammarco, you wanted to say something?
No, I mean, just briefly. I mean, what I heard, I think following up what Svetislav just highlighted, I respectfully disagree with your point on saying retroactively we should not apply the DEMPI function. I mean, honestly, I was one of the Italian delegates on this BEPS project, and BEPS, first of all, was a political project that got a huge marketing impact. It was really well supported, but the question is, in substance, transfer pricing, do you see new concept? I ask you, do you see new concept from 2010 to 2017?
No.
With those of you that work on transfer pricing?
No.
Yes, the acronym, DEMPI, BEPS, cash boxes, beep, boom, bam, Walt Disney, whatever. The question is, if you work with transfer pricing, always a functional analysis will require you that starting point, and this is 1995 guidelines say this, start from contracts, but if you have a misalignment between the actual conduct of the parties and the contractual arrangement, you don't respect that. Now, this, in my opinion, maybe it will be interesting to see what Bulgaria is going to do, is do I consider it as a mere clarification? To me, it's full clarification. So you could apply them retroactively. So, I mean, I'm sure that you have heard of the case of Dolce & Gabbana in Italy, where they made an amazing tax planning, where they set up this IP company where they transferred the trademark in Luxembourg, but all the activities were in Italy. This was a pure tax evasion case that the Italian tax administration challenged, together with other reasons, with that instrument with the 1995 guidelines. It is true that now there is more emphasis on substance, but I don't see new concept. Where I could agree with you more is, what about, we are talking about separate enterprises, but what about permanent establishment, for example? Because now, if you see what is happening there, possibly there I see some misalignment, because the new guidance of 2018 tells you that it is immaterial whether I apply Article 7 or Article 9 from a, I would say, logical order to attribute profits to a permanent establishment. But if you take the 2010 P report, the Part 3 on global trading of enterprises, it tells you that Article 9 conceptually comes first than Article 7. So I have two diverging positions, and in that case, I find very difficult to justify a retroactive application. So the point is, before following slogans, OECD slogan or UN slogan, read the BEPS. Read the BEPS, because those are 500 pages of work, and I can tell you that tax administration fought for years to define whether or not to put words. And if you don't read and you just follow, let's say, slogan, it's very easy then to get misled. So read, study the 2017 report, the 2017 guideline, compare to what was happening in the past. Because often you hear people, taking position from taxpayers and tax administration without having read the report. How many of you have read Action 8 to 10, honestly? Please, be honest. I mean, if you want to work on transfer pricing and you want to engage with constructive dialogue with tax administration, you have to read them. You have to read them. Otherwise, your bargaining position will be definitely weak.
Thank you very much. Two really short statements also from you. Because we have another.
No, I think from a tax administration perspective, because I feel a bit, I fear to be in the minority here. But there is one more sentence in the OECD guidelines, and that we cannot use hindsight in any of our tax audits. So that also provides an uncertainty from our perspective. What can we use and what we cannot? Yes, these are clarifications, and yes, tax administrations and the Hungarian tax administration is one of them to take part in the OECD words, and we are there and we make our word heard. But at the same time, the court of law is the one who will decide on this. I can take an approach, the taxpayer will take another approach. We end up in an audit, we will disagree, and that in Eastern Europe, and that's not only in Hungary, that happens that we go to court then to settle that adjustment. The MAP is not really something that the taxpayers are opting for. So it will be done by the court in Hungary, by the court in Bulgaria, the court in Poland, that will decide actually whether it was a clarification or it is something completely new. And then we will not know the answer until one case is taken to the court and it will be decided.
Again, I would say it should be kept in mind which has higher priority, the arm's length principle or the rule of law and certainty. I think that will be a practical question for the judges to decide as well. Yeah, there are so many examples for discussions about this, in principle.
I would like to take business into defense. Well, I understand that there are hundreds of pages to read, but then a businessman needs to make business. And there was some kind of a deal, what is abusive and what is not. So putting a different comment to something that we maybe knew is changing a perspective. And if there was no discussion about people's function, how much, how many, what sort of is a minimum, then discussing substance starts from the moment we know what tax administration is expecting. So basically what I'm trying to say, transfer pricing is always sort of a deal. Either when a cross-border case is between two tax administrations or internally and as a third-party taxpayer, right? It's transfer pricing is for dividing jurisdictions, right? To tax. So my point is, can you imagine joint transfer pricing audits where tax administration needs to come to some compromise, right? And then you would pick up some arguments for one side and the other for the other sides. There is no like algorithm to discuss each and every case. It's needed to be flexible, and business understanding must be on the table. Some structures were proposed or were common for a business, and then in 2017 we say, well, we don't like them, right? So what I'm trying to say is, let's discuss openly for the future how to approach cases, because on the other hand, we yesterday there was a discussion about cooperative compliance. You need to be you have to have understanding on both sides. You wouldn't have trust if you abuse some transfer pricing cases, right? With argumentation, well, this is in the OECD guidelines and I don't like that you did it in 2006. No time to
well, this is a big topic, I think, and we can organize maybe a conference on this issue. So we agree to disagree, which is great, and it shows that it's a topic that we need to deal with, and it's a topic which we need to clarify. I would like to ask if there is any question from the audience in general, on what we have been discussing so far. No questions. Yes?
I have a question for the representative from the Hungarian tax authorities. To go a step back, if I'm correct, I know Hungary tax authorities was not that active in auditing transfer pricing a few years back, and not to mention APAs. I want to ask, how did that change, and how did you go in Hungary about forming and educating that central management team specialized in TP?
Thank you for the question. I have to admit that I'm all part of the new regime. I have joined the transfer pricing practice of the Hungarian tax administration a year ago, so everything that relates before I have experience, but not a personal one. What was going on in Hungary is that we just didn't have the people, the assets to deal with transfer pricing. It has been changing. There was one single team of about 10 people at the Large Taxpayers Directorate before 2017 that dealt both with the APA cases and the transfer pricing audit. You can imagine, we are a small country, but a big incoming investors economy, so we needed to control this, but there was just lack of experience and lack of people. This has been changed with the 1st of January 2017, when the new setup was established, what I have showed on the slide, and the central management got created. At first only the APA team got there, and then in 1st of November, a second team, the transfer pricing audit methodology was created. So the tax administration as a whole realized that we have to do something. We have to invest in transfer pricing if we want to really target multinationals. I will be taking money out of Hungary. Okay, sorry for the simply said. So we basically doubled the number of people, and I call them really assets, because all those people are the ones who are capable of reading all the OECD documents. Because if you have 6 people, you have to run your practice. You don't have time to really educate yourself. Now the team doubled. We have internally technical meetings of every single week. We go through the documents, of the OECD and really attend the international meetings. We are there and we are making our word heard. At the same time, because that's also more interesting, we are training the tax inspectors. There is a transfer pricing working group that is set up from 10 to 15 people from overall Hungary. It's not at this stage for the whole country, but selected people who are coming in. Every 2 months we have a meeting, we take up cases, we discuss them, and we make guidance to the average tax inspector who is actually dealing with the audit. In addition to that, we are training the tax inspectors. So not only the selected part, but the entire ones. We just finished the document that they will be getting as a background document for the course, and they will have a 3-day course on transfer pricing taught by the central administration to them, central management. So it's a step-by-step approach, but we expect great changes to come.
Thank you very much. Other questions? I know you all really hungry, so I will try to make some final remarks and some takeaway points for everybody to, not just to leave the room with a lot of confusion in mind and to think that we are all disagreeing, but I think the exercise that we are trying to do here is to learn from each other's experiences, and I learned a lot during these 2 hours. I learned, first of all, and this is something that I tell to the students in Vienna in the first lecture, transfer pricing, although it's called transfer pricing, is not about pricing only. If you look at what the OECD is trying to convene in the work on BEPS, is that transfer pricing starts first from an accurate delineation and recognition of a transaction. That means substance. So, although a lot of people, I think, they are focusing on the pricing of a transaction, I think what will come more is to assess that a transaction is happening, that what you have been writing in the contracts is what you're really doing, and that it makes economical sense. It has business rationale. So this is what in the future will change in TP audits, and this is what we need to take more into account in the future. Pricing, benchmarking, this is something important, but it's something that comes only after this analysis. The second point that I wanted to make regards a topic that a lot of countries in Central Eastern Europe are concerned, which is charging of services from Western Europe to Eastern Europe, or from more, let's say, high salary or high income countries to lower income countries. I think this is a big topic that you need to consider into your practice. I see that there is a big variety of behaviors in this regard, and there is always the Western European country that says, I want to charge all my costs, especially management fees, to Eastern Europe because this is what I'm spending in order to run the business, and the Eastern European countries instead saying, or tax administrations at least saying, we can get cheaper services locally. Why should we get those expensive services from Western Europe? This is a big area that will come and is coming already into conflicts, and I think we need to get more clear guidance on this topic, maybe by discussing it more openly. And to this end, I think what was mentioned several times, APAs, especially if multilateral, and we can learn from the experiences that we have been discussing today. Even joint audits, I think Giammarco is a representative of the experience of Italy and Germany in this regard, although it is not, it is slowly flying, but it's an excellent tool that the EU as well is working intensively. Joint audits are also some sort of solutions that we have to consider in the future. Also, I would question whether we should start considering applying transfer pricing to local transactions as well. I know this sounds a little bit absurd to someone, but I know there are some countries in Eastern Europe that do it, and I think there are a lot of reasons for doing that, especially when you have loss carry forward kind of situations or special tax regimes in some areas. Safe harbors. I think we have learned also from the Serbian experience that we can improve these aspects in order to focus on more complex transactions. I think they are useful. However, we need to keep in mind is that safe harbors are simplification measures that we can apply to simple transactions. So don't think that with safe harbors, like Brazil does, we can resolve all the transfer pricing issues, because if you think that you can apply safe harbors for intangibles or even for financing in some cases, I think you are making a big mistake and losing a lot of revenues, both in terms of tax administrations and the multinationals. We need to improve the local guidance and regulations on these topics. I think the initiative of translating the OECD guidance is a great one, and we need, nevertheless, not to be, interpreting guidance only in one direction. Whether we are having an inbound transaction or an outbound transaction, but we should apply guidance and transfer pricing analysis consistently. I think the transfer pricing library project, I think, is a great one that countries should consider as well. Hopefully, those reports that are collected are also read, and of course, that's a big challenge if we don't have enough resources. So this is also the point that I made before. Keep investing in this topic, because that's where you will get a lot of tax revenues eventually in the future for your country. I don't know, maybe one word, one sentence from each one of the panelists before we go for lunch break. I don't want to have the last word because I know that it's going to be too long. So
No, please.
Ladies first.
Thank you for inviting me to this panel. Very interesting discussion. I know where we are in the region, although I'm feeling unsatisfied in terms of substance discussion. Thank you.
Also, thank you for the invitation, and I think the only message that I would like to bring across that please implement APA regimes in the countries, because it's also from a tax administration perspective, it also brings in certainty and ensures the state budget.
Fala, again, thank you for your patience and to postpone your lunch. I mean, the only thing I can tell you is share, don't keep this great event and this discussion an isolated fact. Keep talking, keep sharing experiences. I see a lot of similarities in this region, not only from former ex-Yugoslavian countries, but also Poland, Hungary, Bulgaria, Romania. If you need to establish and keep sharing information to find pragmatic solution, and think long term and not short term.
Yeah, I would like to build on that. Thank you for having for the opportunity to be here, but also adding on Rafaelle's points, what is the future of transfer pricing? I think we should not forget that the tax administrations are talking more and more to each other. So the CBC reporting is the beginning of, I think, what will be in 10 years. The automatic exchange of information scope will increase. So, and businesses should talk more between each other and exchange practices. I think this is the future. So forums like that are a great example how exchange of practices and experiences can improve the overall environment. So this is great. Thank you very much again.
I will use the opportunity for administrative details. I don't have that much smart to say. So lunch is outside. It should be good. So enjoy yourselves. Come back here within 1 hour, and we will have a great panel on tax morale, on behavioral finances. It's something which is very exciting. We have exceptional panelists, and we will close by the presentation of a wonderful book by Stjepan Gađo, who's in the room, our colleague from Croatia, from Rijeka. It's one of the top acclaimed books in international tax law in Europe, and we're proud that somebody from the Central Eastern European region is the author, and I will have the privilege of presenting that book and allowing Stjepan to share with us some exceptionally exciting topics and a real look into the future. So have a nice lunch, enjoy yourselves, and come back because it's not over yet. Thank you.